Village School District versus Kumet. That was 1994, where New York created a separate public school district for members of the Satmar Hasidic Jewish religion in upstate New York. And the Supreme Court said, no, you can't endow a religious group with secular power. So if that's going on there, then I'm with you. But if it's not going on, then it's just a compound. And if they own the property, it's private property and they bought it, why would we want to mess around with that? That sounds like you're just vilifying and demonizing people because you don't like their religion. And I know you wouldn't do that. And let me just say, finally, to uniquely blockade members of a particular religion, here Islam, from participating in government or politics, the kind of thing you do hear from people calling for Ilhan Omar to be expelled from Congress or deported from the country, that plainly violates Article 6, Clause 3 of the Constitution, which says no religious test shall ever be required as a qualification to any office or public trust under the United States. So let's repose some of our faith and trust in the founders of the Constitution. The Establishment Clause, the Free Exercise Clause, the ban on religious tests for public office, they've been working pretty well for America. I think they take care of every single thing that anybody's talking about in this hearing. And I do think we'd be much better off getting back to the work of the country right now, trying to deal with the runaway problem of inflation or to deal with the problem of the continuing administration cover-up of the Epstein files. Any of those, I think, would be a little more valuable, although I've got to say, as a washed-up professor of constitutional law, I do welcome the opportunity to remind people about the First Amendment. I yield back to you, Chairman Roy.
I thank the ranking member for his opening statement, and without objection, all other opening statements will be included in the record, and we will now introduce today's witnesses. First, Mr. Stephen Gallay. Mr. Gallay is the chairman of the Pelican Institute for Public Policy, a nonprofit organization that works to reduce barriers to opportunity in Louisiana. He's also a partner at the law firm of Bevilacqua, Gallay, and Ellis in New Orleans. Mr. Robert Spencer. Mr. Spencer is a Shulman Fellow at the David Horowitz Freedom Center, a nonprofit organization that advocates for free societies. He's authored 32 books on Islam and jihadism. Ms. Krista Child. Ms. Child is the Texas Director for the RARE Foundation, a grassroots organization that advocates for American values. She has volunteered for decades for causes that serve vulnerable populations, particularly women and girls. Finally, Professor Ilya Soman. Professor Soman is a professor of law at the Antonin Scalia Law School at George Mason University. His research focuses on constitutional law, property law, democratic theory, federalism, and migration. We thank our witnesses for appearing today and will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and beliefs, so help you God? Let the record reflect that the witnesses have answered in the affirmative. Thank you, and you please may be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. I'll also remind each of you to turn the microphone on in front of you so that everybody can hear and it'll be inserted in the record. Mr. Gallay, you may begin with your 5 minutes. Is the microphone on?
Now it's on.
Okay.
Thank you, Chairman Roy, Ranking Member Scanlon, and members of the subcommittee for inviting me here today to discuss the phenomena of alternative Sharia law-based institutions, why the enforcement by American courts of decrees issued by such institutions would be inconsistent with the fundamental rights guaranteed by the United States Constitution, and potential legal remedies to prevent such violation of fundamental constitutional rights. I'm an attorney practicing in the state of Louisiana for over 32 years. During the last 17 years, I've had the opportunity, largely on behalf of the Center for Security Policy, to research and study the interaction of foreign law, including Islamic Sharia, with American law. The interaction of foreign law with American law in American courts arises in 4 contexts: the enforcement of foreign judgments by American courts via comity, the application of foreign law in American courts through conflicts of law, the enforcement of choice of law clauses in contracts, the enforcement of forum selection clauses in contracts, the enforcement of arbitration clauses in contracts, and the transfer of lawsuits to foreign jurisdictions under the doctrine of forum nonconvenience. In all of these contexts, American courts and even American law enforcement could be called upon to enforce foreign law, even though the enforcement of foreign law would violate fundamental rights guaranteed by the United States Constitution. I've studied the numerous occasions in which foreign discordant law, including Sharia, has been litigated before American courts. Although the vast majority of foreign law applications are routine and do not violate American constitutional norms, over the past half-century, the number of cases adjudicating the application of discordant foreign law in American state courts, including through arbitrations, has steadily increased. The most prominent category of foreign law that has been increasingly intruding upon American courts is Islamic Sharia law, a body of law which consistently violates American public policy and fundamental constitutional rights, including the rights to equal protection, including equal protection based on race, religion, and gender, the right of due process, freedom of religion, and freedom of speech. Numerous tenets of Sharia show bias against women, the LGBTQ community, non-Muslims, former Muslims, and people designated as blasphemers. Courts in dozens of Muslim-majority nations and some non-Muslim nations currently apply Sharia. In hundreds of reported cases throughout the United States, litigants have attempted to apply Sharia, often succeeding. Examples include the enforcement of foreign child custody judgments or jurisdiction not based on the best interest of the child, but instead based on gender or religious discrimination. The transfer of cases to foreign countries whose courts discriminate on gender or religion. The enforcement of Islamic marriage contracts, dubbed Mars, as prenuptial agreements. Talaq or other Sharia divorces, and increasingly the creation of arbitration tribunals applying Sharia law within the United States. The law applied by such tribunals discriminates based on gender and religion, and in cases of custody disputes, does not apply the best interests of the child standard. Those arbitration tribunals also lack traditional American legal formalities, lessening due process. Furthermore, legislation of the past half-century has suppressed certain American legal protections against the intrusion of discordant foreign law. Public policy exceptions and common law rules have been overwritten by uniform acts adopted by the states, sometimes related to foreign treaties. Some uniform acts now treat foreign country judgments like sister state judgments, essentially extending the full faith and credit clause of the United States Constitution to foreign nations. Moreover, the U.S. Court of Appeals for the Ninth Circuit has explicitly held that foreign court orders are not subject to the constraints of American constitutional law. Responding to this encroachment of discordant foreign law into the United States, multiple efforts have been undertaken, primarily at the state but also the federal level, to address discordant foreign law. The model statute, American Laws for American Courts, passed in some form in 13 states to protect fundamental constitutional rights against the infiltration of foreign law, such as Sharia. Additional state acts and federal acts have also passed, including the Speech Act. Americans for over 250 years have toiled and suffered, including spilling blood, towards guaranteeing fundamental constitutional rights. No U.S. citizen should be denied the fundamental liberties guaranteed in our constitutional republic. The intrusion of discordant foreign laws, including Sharia, into the American legal system should be resisted. Thank you for your time, and I look forward to answering your questions.
Thank you, Mr. Glay, for your testimony. Mr. Spencer, remind you to turn your microphone on, and you have 5 minutes.
Thank you. The U.S. Constitution and Sharia are incompatible, and the conflict between the two legal systems will grow as Sharia adherents increase in number in the West. This fact has been obscured by misinformation about what Sharia actually is. When the city of Keller, Texas, scrapped an anti-Sharia resolution in January 2026, the Hamas-linked Council on American Islamic Relations, CAIR, stated that like canon law for Catholics and halakha for Orthodox Jews, Sharia refers to the rules that Muslims follow including praying 5 times a day, fasting in Ramadan, giving in charity, and following the laws of the land in which they live. If that were really all that Sharia were about, no reasonable person would have any problem with it. CARE doesn't mention, however, that Sharia is inherently political, supremacist, expansionist, and violent. Far from being the Islamophobic conspiracy theories of CARE's imagining, these are facts that Muslim authorities on Sharia openly attest. Reliance of the Traveler, Umdat as-Salik, is a classic manual of Islamic sacred law, that is Sharia. In 1990, Dr. Taha Jabir Alawani, president of the International Institute of Islamic Thought, as well as president of the Fiqh Council of North America, stated that this Sharia manual was useful as a textbook for teaching Islamic jurisprudence. The most prestigious institution of Islamic learning in the world, Al-Azhar in Cairo, stated in 1991 that the same manual of Sharia conforms to the practice and faith of the Orthodox Sunni community. We read in this same guide to Sharia that jihad means war against non-Muslims and that it is a communal obligation upon the Muslim community. The object of this war is to establish the hegemony of Sharia over the conquered land. For non-Muslims, this means an institutionalized, highly codified second-class status that denies them basic rights. Non-Muslims living under Sharia must pay the non-Muslim poll tax, jizya, that is specified in the Quran, verse 929,